No, Mr. Poon.
Lords, my lady, before I look at what Miss Ellis told the appellant, I'd like to just finish looking at the statutory framework, which hopefully won't take very long. And I can start by making this point, that Chapter 3 distinguishes between three classes of appointment. Permanent appointments by way of promotion, and that's dealt with by Regulation 18. Acting appointments made as a prelude to a permanent appointment, and that's dealt with in Regulation 24. And acting appointments which are not a prelude to a permanent appointment, and that's dealt with in Regulation 26. And the principles governing these three categories are different. So starting with promotion, you turn to page 982, and in answer to a question by my Lord Kitchen, we looked at this already, the definition of promotion there at 982 in the regulations. So an appointment of an officer to an office of grade carrying a higher remuneration. And then Regulation 18 is dealing with the principle of selection, which is at page 988. So we see at 988 at the bottom, in considering the eligibility of officers for promotion, the Commission shall take into account seniority, experience, educational qualifications, merit and ability, together with relative efficiency of such officers, and in the event of inequality, two or more officers shall give consideration to the relative seniority of the officers available for promotion. Then there's a point at sub-regulation 2. Then at sub-regulation 3, the relevant factors to take into account, and perhaps if I can just emphasise three of those. Little b, the position of an officer's name on the seniority list. Little g, the duties of which she has knowledge, and little j, any previous employment in the public service or otherwise. So they are the factors that, by operation of Regulation 18, the Commission is required to take into account when selecting for permanent appointment by way of promotion.
Irrespective of the class of activity.
Yes. And that's why I say when one looks at cases such as the recent case that was handed up this morning of Jai Paul, I say it has very little, gives very little assistance to the board when considering the facts of our case, which is not a promotion case. And just to make good that point, by reference to Jai Paul, and I think the board has, for these purposes, the necessary facts are just to acknowledge that the claimant in that case was appointed initially to the post of Clerk 1 in the Ministry of Works and Transport. And 3 years later, he applied for effectively a promotion to the position of Customs and Excise Officer 1. Now, point I already made in answer to a question by my Lady Black, Clerk 1, that's an entry point into the clerical class. And we see that from Regulation 5 of the Civil Service Regulations, page 954. And at 954, Regulation 5, dealing with the clerical class, sub-regulation 1, entry into the clerical class shall normally be in the grade of Clerk 1. And then it goes on, candidates for appointment to such grade shall not be, and then it stipulates 17, not more than 23. And then we turn over the page, 955, little c, promotions or transfers to vacancies reserved in accordance with para B shall be made by the appropriate commission on the basis of the order of merit of the candidates who have passed the prescribed examination. So they are the specific regulations governing where Mr. Jai Paul started out as a Clerk 1. He applied for promotion, and that was the subject of his complaint in this case, to a technical clerk, officer in the technical class, Customs and Excise Officer 1. And what is relied on by Millennium Friends is what is said in very general terms by the Court of Appeal. At paragraph 4 of the Court of Appeal's judgment, I think what in particular they rely on is the last two sentences. So the Court of Appeal recording that candidates...
Just give us the number again, please.
This is a hard copy. This was the case that was handed up by Millennium Friends.
Oh, yes,
this
I see.
morning.
Sorry, I'm sorry.
I think you were given the first instance judgment, but I'm looking at the Court of Appeal judgment.
Yes.
Paragraph 4, last two sentences. Candidates were assessed on the required knowledge, skills and abilities from an order of merit list, and it's the established practice and procedure of the PSC that promotions are based on the ranking and placement of officers on the order of merit list. And what I say there is, this was a case that was concerned with promotions from the administrative class to technical class. I say the nature of the class is perhaps immaterial, but it's a promotions case. As we've seen from Regulation 18, different considerations apply when considering promotions. We've seen from Regulation 5, dealing with the administrative class entry point, that the order of merit list has a specific function for this class of officer. So the present case, I say, is very different, and it doesn't assist Millennium Friends to point to what an observation made by the Court of Appeal in the context of an entirely different case dealing with promotions. And this perhaps goes to the point that we make in our written case, at paragraphs 26 and 27, page 339, and the point I've already made about this being a new case. The point we make at paragraphs 26 and 27, by reference to the case of Baker, and it being the normal practice of the board not to allow a new case to be advanced before it for the first time. If it is going to be said, as it appears to be in all submissions, that is the practice of the PCS, in a case of this nature, for an initial appointment to a technical class post, to effectively be bound to appoint based on the order in which your name appears on the order of merit. Then I've already made the point, that's a different case to how it was put below. But the relevance of this in the context of the case of Baker that we refer to in paragraph 27 is there would have been different evidence led in my submission below, because we would have had the respondent would have had to address that point square on. Now I say there is evidence, and the evidence was the evidence given from Miss Harding, and I'll come to that when we look at the representations, as to what the practice and procedure was that runs contrary to what is said by Millennium Friend, and in particular by Millennium Friend Mr. Ramley, practice and procedure. So that's...
But there would be further evidence. There would be other evidence had the case been made below.
Yes. That's the point on, if you like, the first category of appointment, so that's promotion. And just very briefly, the remaining two categories are acting appointments. One is a prelude to a permanent appointment, one is not a prelude to a permanent appointment. The reason I say something about this is because the term acting appointment and temporary appointment is used interchangeably by both in the written case and in all the submissions. And I say there is a distinction to be drawn, and it's an important distinction when one looks at regulations 24 and 26, because again, different selection criteria apply. And the distinction I say is an acting appointment is defined by Regulation 2 of the Civil Public Service Commission regulations at page 981. Acting appointment means the temporary appointment of an officer to a higher office, whether that office is vacant or not. And it's a point that we make at paragraph 41 of our printed case at page 344. Acting appointments concern those already employed within the public service. Acting appointment is not the same as a temporary appointment. In my submission, a temporary appointment means an appointment of a person to a temporary office or the appointment of a person temporarily to a permanent office. And that's not just my interpretation of the phrase. We can see that from the civil service regulations at page 953 that define temporary appointment in those terms. And I do say it is a distinction that has to be borne in mind when one looks at the representations that are relied on in this case, but also in Millennium Friends' submissions.
But you referred to Regulation 2 on 981, and 981 says acting appointment means the temporary appointment of an officer to a higher office or otherwise. So if you take out the higher office because of the words or otherwise, it means the temporary appointment of an officer.
Yes, but you said that those words are vital because it's in the sense of acting up.
Yes, it is an appointment within the civil service, so it's an appointment of an officer, so someone that's already in office, effectively being promoted, and as my Lord Care says, acting up. And I say, should it be said against me, and it's not in terms, that or otherwise somehow changes the meaning of that expression. That was a point expressly considered by the board in the case of Singh, which the board has at tab 21, page 841. And it's the speech there of Lord Carneth at paragraph 12. I think it's only fair to say, and I can turn it up. It's fair to take a point that it's a strictly obiter remark, because did not need to be determined to dispose of that appeal. Paragraph 12, where Lord Carneth said, in the board's view, the respondent is clearly right under issue 2. That makes it unnecessary to reach a concluded view on issue 1, although the board sees some force in the respondent's submission that is concerned with promotion in the true sense. And you see the way that issue 1 is phrased at paragraph 7 of the judgment.
Yes, of course. Yeah.
And so the point we make is you must distinguish between, or you should distinguish between acting appointments and temporary appointments, because acting appointments are dealt with specifically by regulations 24 and 26, which have different principles of how you look at seniority when making those appointments. If I can then turn very briefly, because we've looked at them already, but the representations, and as my Lord Hodge says, I don't need to go back to the affidavits. I live with the judge's findings in this respect, and so the relevant findings are at paragraph 11, page 221, and paragraph 22 at page 224. But the point I make about the representations is that Miss Ellis appears to be dealing with two things here. She is dealing with promotion, and she is dealing with permanent appointment.
So it's the findings are paragraphs.
So paragraph 11 at page 221.
Yeah.
So it is therefore accepted as a matter of fact. And then at the top of the following page, any special claim to promotion as promotion and permanent appointments were based on an officer's place in the order of merit list. And then paragraph 22, it's in fact at the top of page 224. This court finds that the balanced probabilities the claimant visited the officers and was assured that appointments would be based on the order of merit list.
Yes, thank you.
And what you say at paragraph 11 is effectively lifted from the appellant's affidavit. That's how he expressed what was told to him by Miss Ellis. But what is being dealt with there, as I submitted, is promotion and also permanent appointment. And I have four points to make on the representations and what the respondent says about the practice and procedure of appointment. The first is that what Miss Ellis says about promotion is wrong. It is contrary to the express provisions of Regulation 18, if what she is taken to be saying is that promotion is based solely on your position on an order of merit list. Second, as already discussed, there is nothing within the regulations to support what Miss Ellis says about permanent appointments being made solely on the position of a candidate's name on the merit list.
I'm sorry, I didn't hear that. Nothing in regulation supports...
There's nothing in the regulations to support what she says about permanent appointments being made based solely on the position of a candidate's name on the order of merit list. And perhaps more importantly, thirdly, in my submission, the evidence points against the Commission having such a policy to appoint exclusively on the position your name appears on the merit list. And I say that based on Miss Harding's evidence that appointments are made on a case-by-case basis, and the reference for that is her affidavit, paragraph 12, page 152. She was cross-examined narrowly. Permission was given for her to be cross-examined on that particular paragraph, and in cross-examination she said that the order of merit list was used to determine suitability and is not always the basis on which the Commission promotes, and the reference for that is page 213. And stepping outside her evidence, I say the fact that this is not the Commission's policy is borne out by the very facts of this case, namely that the 10 comparators that the appellant identifies were appointed to permanent positions before him. And the reason given by the Commission for that was that they had more experience in the precise role that they were applying to be appointed to as a permanent position. So put simply, I say the treatment that was meted out to the appellant and his 10 comparators establishes what the true settled practice was in this case. And my fourth and final point, just on the representations and practice and procedure, even if that was the Commission's policy, does not, in my submission, mean that it cannot be departed from in appropriate cases. I say it wasn't the policy, but if it was, the policy cannot be so inflexible as to automatically determine the outcome.
I think that's a rather difficult alternative argument to make, is it not? I mean, one would have to examine the reasons for the departure from the policy, and since you're asserting that it wasn't the policy, an examination of the reasons of the departure from it is slightly surreal.
I take your Lordship's point, but what we have got, though, here, because of the justification question and the evidence that was led on justification, is that we have got the Commission's reasons for departing from, if you like, the policy that as it was expressed by the appellant. So their position was, well, that's not our policy, that's not our practice. But the reason we made the appointments of the 10 comparators before the appellant was appointed to the appellant position was precisely because of their previous experience acting in the role of Road Officer 1. And I submit, by analogy, one can usefully look at the Regulation 26 cases. So Regulation 26, which is dealing with acting appointments, that contains a general rule of seniority. And that was considered by the board in the case of Singh and the Public Service Commission, which we find at we looked at tab 21, page 841. we see there at paragraph 1, this was a case where the complaint was that the appellant had been passed over for appointment and a number of junior officers had been appointed ahead of him, contrary to the general rule of seniority imposed by Regulation 26. And at paragraph 9, the board records the fact that appointments were considered by reference to the date of qualification, which was an entirely rational policy for a job requiring some technical expertise and a justifiable departure from the general seniority rule. I entirely accept we're not within the confines of Regulation 26. We're not dealing with acting appointments. But I submit the same considerations apply in the present case. I submit it's entirely rational for the Commission to take into account relevant experience when appointing to a technical role, such as Road Officer 1. In fact, I go further than that, and it's the point we make in paragraph 38 of our printed case at page 343.
Sorry, paragraph?
Paragraph 38 at 343, and submit that a decision based solely on an out-of-date order of merit list would have been open to challenge. And we cite at paragraph 38 the case of Raj Kumar and Lala, which you have at tab 17, page 734. And there was a challenge to the failure to promote the appellant to a position of a prison officer 2. There is discussion then at paragraph 10 setting out the Public Service Commission regulations. And then the point we pray in aid of at paragraph 21. The Lordships have reached the conclusion that in restricting consideration of the appellant's promotion to the Order of Merit List of 1995, already 3 years old, and disregarding the other matters referred to in Regulation 172, in particular E, an evaluation of the officer's overall performance as reflected in annual staff reports, the approach taken to the decision on the appellant's promotion was fundamentally flawed. Now, again, I don't say that case is on point in the sense that it is dealing here with an initial appointment in the civil service. That again is dealing with promotion. But I say it makes good our submission that it is entirely rational for the Commission to take into account relevant experience rather than, as the appellant would have it, limiting itself solely to the position your name appears on an out-of-date Order of Merit List. I can next deal, again, hopefully briefly, with how the appointments in this case were made in practice. So I'm moving away from the sort of statutory framework analysis and what we say about the practice and procedure. And so I'll keep the rest of my submissions fairly brief, given the board's indication at the start of my submissions. Dealing then with what I term the appellant's attitude to temporary appointments. I don't say that, as Lord Jones said, it's not a question of blame, but it is relevant here to note that it is, the findings of fact have been made that the appellant on more than one occasion was written to elicit his interest in accepting a temporary appointment. So prior to 1990, and contrary to what the letter of Mr. Ramlogan submitted, it was only in 1990 that was the first time he was asked whether he wanted a temporary appointment. That is not what was found by the judge at paragraph 6 at page 220. The judge found that the appellant's general response was that he preferred to wait for an appointment of a longer duration, which in my submission is entirely consistent, in fact, with what his own evidence was, and this point my Lord Kitchen noted by reference to paragraph 8 of his affidavit at page 35, that the letter of the 7th of May 1990 was asking him whether he was still interested in the temporary appointment.
I think the letter that he wrote in August 1995 did refer also to earlier communications.
My Lord, yes, and in fact the letter, one of the letters he wrote expressly stated that he was effectively, the letter at page 62, he was interested in, his words, a longer-term arrangement rather than such a short stint, was how he put it in his own words in that letter at page 62. But unlike the appellant, as at
It was page 60.
Oh, my Lord, sorry.
Paragraph 2, I received numerous letters from your department during the period 1986 to 1987 inquiring whether I was still interested in the job.
My Lord, yes, and there was a point that was explored in evidence here, because the appellant's position when he was cross-examined, he drew the distinction between letters being written to him asking whether he was still interested in the job and letters being written to him asking whether he was interested in a temporary appointment.
Yes.
And he tried to effectively suggest he didn't receive any of the second kind of letter.
And that wasn't accepted.
And that wasn't accepted. And he was cross-examined on that.
Yes.
And the letter that I had in mind was the next letter in the bundle. So it is at page 62, and that's where he says, this is a September 92 letter.
Yes.
He was indicating his interest in a longer-term appointment rather than a short stint. But unlike the appellant, as at the 7th of May 1990, that being the date of the first representation relied upon, all of his comparators had taken up temporary appointments as road officers from dates ranging from 1986 to 1987, and had generally remained continuously employed and performing those duties until they were permanently appointed in 1993. And we, again, don't need to look at the affidavits. We've got findings to that effect. The judge's findings at page 226 at paragraph 29, and the Court of Appeal did a bit more legwork, if I can put it like that, because at paragraph 23 at page 266, they in fact, the Court of Appeal analyse in a table the length of temporary appointments of all of the comparators. So it's at paragraph 23 of the Court of Appeal judgment, starting at the top of page 267. What they don't do is they don't add up the time, but I can tell the board that effectively they are all, on that page, they're all 4 years or thereabouts. Over the following page, the first two are 4 years. The Roman 9 is just a bit shy of 4 years. Roman 10 is 2.5 years. And then you have the appellant. And it is that relevant experience that meant that the 10 comparators were appointed in advance of the appellant. And we see that from the reasoning of both lower courts. First instance, page 231, paragraph 4. And in the Court of Appeal, 273, paragraph 35. Whilst we have the Court of Appeal's judgment open, I think it's relevant to, and I'm sure the board have already read paragraphs 40, but there the Court of Appeal acknowledged, as at 7th of May, that the appellant's comparators had served significant periods of time as road officers, which warranted special consideration and different treatment. They make the point at paragraph 41 that even if the appellant had taken up appointment that was offered to him on the 7th of May, it wouldn't have made much difference because his comparators would still have clocked up about 4 years of relevant experience. And then at paragraph 42, they say their concern is whether there was different treatment. And they go on to say, in my judgment, there was a different treatment, but it was justified. And they make the point that had he started acting on the 7th of May, would still have been well in advance, his comparators well in advance in service compared to him, and that's sufficient to justify their appointments to permanent positions ahead of him. They acknowledge at 43 the overlap between the sameness question and justification question. And at 44, the core aspect of their reasoning on justification. They say the Commission must be concerned with appointing both competent and deserving officers, and in this case the decision struck a balance between merit and experience that was both rational and proportionate and fair. And they make the point that in discharging a duty will be faced with competing interests. The interest of fairness will sometimes require a Commission discharging its duty to consider particular circumstances of a given case. Doing so, the Commission cannot be expected to adhere inflexibly to a fixed policy, and to do so will produce an unjust result. And then at 46, they say that the Commission properly explained the basis of different treatment. And our overarching submission, unsurprisingly, is that the Court of Appeal was plainly correct to reach the conclusions it did on the evidence before it, and dismiss the appeal on that basis. Equality requires persons should be uniformly treated unless there's some valid reason to treat them differently. And here, the valid reason was that the comparators were treated differently because they had previous experience of working in the post of Road Officer 1 for extensive periods of time. And a point I've already made is that it's entirely rational to take into account experience of acting in a post, particularly where you're appointing to a post that is a technical post. No, my lady, I take that point. We know it is a technical post. I don't know, and I can't tell you what it exactly requires, other than, I suppose, to go back and point to Regulation 11 of the Civil Service Regulations that makes it clear that for these positions you need professional qualifications. But beyond that, I can't tell you precisely what a Road Officer 1 would be doing on a day-to-day basis, or how that differs from a Road Officer 2. But if it would assist the board's reasoning, I'm sure between the parties.
Well, it's not so much that it will assist in our reasoning. It might appear slightly incongruous if we give a judgment which is divorced from any description of what it involves.
Well, yes, and it will be fairly straightforward, I imagine, to come up with a job description, effectively, of Road Officer.
It may not be a million miles from the reasoning either, if you're saying experience is relevant.
I agree.
It's better if we know something about the job.
I can see that.
Yes, because when you go back to section 11, there are three criteria, which are alternatives. One is technical qualification, another is a course of training, and another is an examination testing practical experience and ability.
Lord, my lady, those are really the submissions I have on what I said I would be addressing, which is the structure of the statutory scheme, and then how the statutory scheme applied in practice. Just briefly, then, with the remaining points, which I will deal with quickly. The point taken on Webster, we deal with this at paragraphs 19 to 24 of our printed case. We make 2 points. First, that the point that's being raised by the appellant actually has no bearing on the outcome of this appeal, because there is no challenge to the Court of Appeal's finding that the situation of the appellant and his comparators was broadly similar. So it's an academic point, which is a point acknowledged by the appellants in the Statement of Facts and Issues. And then secondly, we say nothing in Webster, in fact, is at odds with what the appellant is in fact saying. And we agree, and we say this in our written case, that rigid formalism is to be avoided when considering whether there has been unequal treatment. And that's expressly recognised by Lady Hale in what she says in Webster. Our submissions on ground one, namely the allegation of acting unlawfully under the regulations, you really have my points already by reference to what I've said about the statutory scheme, there are two preliminary points we raise in our printed case, which I will leave in the printed case and won't expand on orally. They're paragraphs 26 to 31, pages 339 to 341. You have heard what I say about on the first preliminary point already, which is that this is the argument being advanced under the regulations is a new argument. And I don't limit that. My learned friend has expressly abandoned what he says the new argument is, which is his reliance on regulations 24 and 26.
You say regulation 12 is in the same category.
The entirety of the argument on regulations is a new what I say on that, and it's in our printed case. The second preliminary point we take is that the public law nature of the challenge being made makes it an abuse for the appellant to run this argument within the confines of a constitutional motion. And as I say, that's set out in our printed case. It's paragraphs 29 and 31. Sorry, yes, 29 and 31, by reference to well-known principles in cases such as Harricassoon. As regards the merits of ground one, as I say, you have my submissions really by reference to what I've said about the statutory framework. Ground two, legitimate expectation, I will say, keep my submission very short. We summarise what we say in response at paragraph 46 of our printed case at page 345.
It's not clear to me that the legitimate expectation case is maintained against you.
My Lord, and if that is the case, then I will the submission is extremely short and simply refer you to our printed case, if that is right.
So I'm not trying to discuss.
No, my Lord.
I'm dealing with it.
The difficulty is, like any advocate, unless something is formally, like the new case under 24 regulations 24 and 26, in Otis and Leonard Friend formally abandoned that. He hasn't done the same in respect of.
Right.
It is our usual practice that we treat everything in the written case as still before us.
Yes.
Well, do you want to say in a couple of sentences anything in amplification of what you say in your printed case?
My Lord, I will try to keep it to a couple of sentences. There are really 3 points. We say
3 points and 2 sentences. That'll be very good.
sentences with some semicolons in the middle. First point, we say legitimate expectation does not bear on the issue of unequal treatment. What I mean by that is it's a point Lord Jones made in asking questions from a learned friend. It is that the representations here relied on do not give rise to the difference that is said to explain and justify the difference in treatment. The material difference, namely the prior experience of the job they're applying for, was already present when the representations in which the appellant relies were made. So if analysed in terms of legitimate expectation, there's nothing unfair in the Commission taking that material difference into account. The second point, we say it would be wrong to hold the Commission to the representations made by Miss Ellis, and you really have the points there that I have addressed when looking at practice and procedure, namely what she says about promotion is wrong. There is nothing in the regulations to support what she says. The evidence points against there being a policy in the terms that she expressed herself. And perhaps I just add one point to that. If we are looking at this in terms of legitimate expectation, and I don't say that this is a case where the board needs to reconsider what it has only recently considered in the Finucane judgment, namely the question of reliance or detrimental reliance, and whether that's a prerequisite for substantive legitimate expectation. I don't put it in those terms. I say that the lack of reliance here weighs heavily against holding the Commission to a promise. And then the third point, justification, we say even if what was said amounts to a substantive legitimate, gives rise to a substantive legitimate expectation, the Commission has plainly justified its frustration of that And that's the point about relevant experience being a rational criterion to take into account for all the reasons that the Court of Appeal gave. So, my lady, unless I can be of any further assistance, that's the respondent's case.
Thank you very much indeed, Mr. Mr. Clayton.
My Lords and Lady, one of the striking features of this case is the weakness of the evidence advanced by the respondent, which is a subject I'm going to come back to very shortly. But the first point I wanted to address was his riposte, if I may call it that, to the assurances, in fact, 2 assurances given. But it's worth noting this at the outset. These assurances were given by Miss Ellis. No explanation in the witness statement as to what happened to her. No explanation, for example, that she's no longer employed by them or anything like that. The reality is a tactical choice was taken not to get any evidence from her. We're then told by my friend that there are 4 particular reasons which demonstrate the assurance have no force. That, with respect, cannot be sustained. His first point is that Miss Ellis said nothing about promotion, which is what Regulation 18. Well, we agree. It's also completely irrelevant for the purposes of this case. The second thing he says is that Regulation 12 says nothing about permanent appointments. Now, just to remind you at this stage, we put our case 2 ways, either that Regulation 12 applies or that there's a policy to give effect to Regulation 12. And if you turn to the relevant, if we turn to Regulation 12, which we can pick up again, I think it's in 995. With respect, it's absolutely plain and plainly covers this situation. Candidates for permanent appointments, etc., shall be selected on the basis of written competitive examinations and interviews. I mean, it could hardly be clearer. So, with respect, his suggestion that Regulation 12 doesn't apply to permanent appointments is rebutted by the very language of the regulation. The third point he makes, or purports to make, is the evidence tells against the claimant's submission. Well, with respect, that is unsustainable for obvious reasons. The practice that the respondents deployed in this case is the very issue in dispute in this case. How on earth, other than lifting oneself up by one's bootstraps, can one say that a contested explanation based on what they've done is unequivocal evidence? That's the very debate that we're inviting my lord and lady to determine, and it doesn't take him anywhere. But more serious than that is he said that there is evidence that the Commission were entitled to rely on experience. Where is that? Not a shred of evidence anywhere. It's not a self-evident truth. It's not a divination. If that is a case which is being advanced, especially in a context which my lords will know, it's on the respondents to discharge the burden which lays on them to file some evidence. There is 0 evidence on that subject. 0. In fact, when I went through the somewhat inadequate, a phrase I take from Lady Hale in the Webster case, explanation for which that is given for this case, there is almost no evidence about what the practice is. So far as I can see, and I've been taken to all of this, there's paragraph 4, which appears at 150 of Harding's affidavit. There's paragraph 6, which also appears at her affidavit. And paragraph 12, which is the important one about the assurances given to temporary staff, which appears at 152. That is it. And that, with respect to my friends, is simply inadequate. Moving on to a slightly different point, the inadequacy of the evidence adduced in this case is really somewhat troubling. It's not only the case that my lords have no exhibits, which my friend Mr. Ram Logan pointed out, but I would invite you to turn to the explanation which was given to the judge to refuse the order for disclosure. It's at 180. And it, with respect, is not a happy read. Can I ask you to turn it up, please? 180, paragraph 5. have it. Disclosure is permissible under Part 28.6 where it is necessary to dispose fairly of a claim or save costs. Here, disclosure is sort of minutes of a meeting in terms of an appointment. First, the paragraphs 18 that do not deal with minutes but recommendations for appointments. Well, with respect, so what? It's perfectly obvious what the request is. Secondly, it said, recommendation is not necessary for fairly disposing of the claim of alleged discrimination. Well, with respect, in our submission, they stand or fall by that. It's obviously relevant. They chose not to put it in. And indeed, they persuaded the judge, who gave no reasons, to refuse the application. That, when one's testing the adequacy of a justification, is not terribly helpful. And it is worth emphasizing, if I may, just how poor the justification is when there is this obligation on a respondent. What he says, well, the way in which the Court of Appeal deal with it, is, I think you find it at 274. Can we just briefly look at that? Picking it up from paragraph 40, it's all in the same vein. Even if Mr. Sahatoo had accepted the acting appointment when offered, other officers had already been acting continuously as road officers for some 4 years prior. Now, that may be relevant in terms of the impact of the assurance, but it isn't an explanation for why the assurance was given, which is in fact in line with the policy and or Regulation 12 itself. It's no answer to it. And in fact, the central issue in the case is left wholly unanswered. Because nowhere is there an evidence from Ellis saying, I didn't say it, or I did say it, or anyone else saying, well, why on earth it was said and what it was intended to convey. I mean, in our submission, it means what it says. And what it said was something that the defendants, forgive me, respondents have sought to refute by relying on a practice which they, in a bootstrap kind of way, say, well, the practice proves the practice is okay, which it does, obviously doesn't.
Well, it's not disputed that it was said. I don't know that it's
No, I understand that, but what it was intended to convey when it comes to justification may be important. It's no answer to say, well, it's partly an answer to say it may not have been substantively detrimental in the circumstances of this case, but it doesn't explain the, if I may put it this way, the sense of disquiet the recipient might have had about being the subject of two assurances which have never been explained. And that's not a trivial factor in our submission.
right.
Then, so we say that on the central question, what was the reason for the departure from the assurance given, there's simply no answer in the evidence at all, and it should have been. And the third point I want to draw attention to is really just looking at the evidence of the whole, just it's the absence of real cogency in it. No exhibits, no explanations for obvious things. It's so thin that it plainly falls within the category of inadequate by reference to Lady Hale's comments in Webster. So what it comes to, my lords and ladies, is as this case developed in the Court of Appeal, it was up to the respondents to discharge a burden. The burden fell squarely on them, and they simply didn't. If you scrutinize the evidence, it doesn't help them to the extent that you would expect it. And in particular, it may be that I've got this wrong, but I don't think I have. There is no evidence that experience was a justification. There's assertions to that effect, but that's not the same as evidence.
You haven't discovered what a road officer does.
But,
You haven't discovered
I have actually a bit. What I was going to say, I'm now handicapped by not being able to read.
A bit of what he does.
But
You've discovered a bit.
I took a hasty note, but apparently it's essentially a construction type job. Job description would be a better approach, but it's It's because unsheathed. I apologise. The position is that it's about maintenance of bridges. It's a kind of construction type job, but quite obviously it would be sensible for a job description. I mean, I only have what I've just been told. But
Well, when you say a construction type job, is it as a supervisor or as an engineer?
It includes supervision as well.
Right,
Oh, I'm sorry, forgive me. I'm told it is a supervisory job.
yeah, right.
But I would say, it may sound a trite point, but really, what one might have expected to see was evidence from the other side, say, for heaven's sakes, this is what this person does, and experience that this sort of thing day to day is important. Now, it may be, I don't know, that had that been put in, evidence and rejoinder, you'd say, golly, this is what I do all the time anyways. This is nothing new for me. I could do this immediately.
Well, that might be dangerous enough territory for you, Mr. Clayton, because one might have expected some representations from the appellant as to the need or lack of need for experience.
Well, I accept the force of that too, but in the end, I take recourse in the fundamental point about the onus, not because I'm making an empty point about where onuses lie, but it's particularly important in a discrimination case to remember where onuses lie and justification. And all I am saying...
You have reminded us
I know.
sufficiently. Thank you very much.
Thank you.
But entirely properly, too.
All I was really saying, and forgive me if I got this wrong, one might have expected some of that to appear in witness evidence.
Right.
Subject to checking with everyone around.
Yes, yes, by all means.
Can I just check something?
Of course.
Oh, I'm so sorry. Can I take you to 152 to correct something I said? It shows that however quickly I read, I can never keep up.
152.
152, please. This is the explanation about Ellis. And I'm grateful to my friend, Mr. Richards. The Commission, sorry, do you have it, paragraph 11?
Yes.
The Commission can find no record of a claimant visiting his office in response.
Which paragraph is it?
11.
11. Oh, yes, thank you.
The Commission can find no record of the claimant visiting its office in response to the said letter, nor of his speaking, I'm sorry, I'm completely wrong, nor of his speaking with Miss Ellis, who is no longer in the employment of the Commission and resides outside the country. Oh, no, they have tried to contact her, okay. So that is a perfectly sensible explanation, I accept that.
So I was surprised at your submission because
Well, I'm
I was
sorry.
told that passage.
Well, at least I should have the capacity to surprise, if not by the accuracy of the submissions. The point I'm making really is that I mean, I accept that takes it as far as it goes, but I don't resile from any of the points I made earlier about evidence.
Yeah.
Is there anything else? My lords and ladies, if there's nothing else, thank you very much.
Well, thank you very much indeed, Mr. Clayton. The board is indebted to counsel for the presentations and, of course, to counsel who so ably assisted in the preparation of the written submissions. The board will take time to consider its judgment, and the court is now adjourned.